So welcome for those of you first time attending our YouTube channel, or for those of you attending a workshop of ours. We are going to be producing one of these workshops per month, and it's going to run twice in the same month, a couple days apart from each other, in different locations and in different venues. And you can register to attend a workshop in person, and when you do that, you are basically allowing yourself to get down in person with your forms, any kind of legal forms that you have, whether it be in any kind of court or tribunal or administrative body, any kind of legal forms that you need assistance with, either understanding or having questions answered about something specifically, and not about what to put exactly in the fields of the box. So what should go in specifically? That's what we won't do. We're not going to fill it out on your behalf. We're not going to tell you that this should go in this spot over another. But what we will do is answer, what something is, give you legal information as to what specifically the form is looking for, and what it is that the purpose is of that section of the form or whatnot. And that's all stuff that we're doing in person, and that will come after the prepared presentation portion of this seminar or workshop. And today's topic is about similarities and differences of all courts or tribunals. And this is something that is of great importance, I would say, to most self-represented litigants, because understanding one process will help you understand the other processes in other venues. And when I say venues, that could be a courtroom, an administrative body like a tribunal or a board or a commission. And that is something that once you know the formula or the recipe, you will know the recipe to follow in other venues. So where I'm going to be talking about the distinctions between the two and the similarities between the two types of venues, today this is something where, as a general rule, once you know what the similarities and differences are, in my mind, you'll now know what to expect when you go into any kind of hearing. And in general, what you're going to experience in Canada, at least, are two different types of judicial bodies that make decisions or that try facts. And when I say try facts, I mean, have issues put to them and have facts determined by an independent judicial panel or a board or a judge. And when we talk about administrative law, we're talking about, in general, we're talking about tribunals, commissions, or boards. It's thrown around that there is the ABCs of administrative law, and that being agencies, boards, and commissions. Obviously, an acronym for ABC, being those three types of bodies. And then on the opposite end of the spectrum, we have the judicial realm, if you will, and the judicial realm encompasses courts and family court, small claims court, appeals courts. And these are the two main, or the two primary triers of fact, or venues or types of jurisdictions that we have here in Canada. In most of the world, you're going to find something similar throughout, but we're just focusing today on Canada. And if something is applicable to you, I hope that this can be of help to you. And if not, send us a comment or an email on the website, or comment under this video, and you can find, hopefully the answers to your legal questions. But that's what I want to emphasize here today, is that this is not legal advice, and that this is going to be a lot of legal information from my training. I am trained as a paralegal in Ontario, Canada, and if you don't know, paralegals essentially work in the same realm or capacity as lawyers in Canada, and that's just in the jurisdiction of Ontario, I should say. And that should be distinguished from paralegals in other parts of Canada or other parts of North America. Paralegals may do different things, but essentially a paralegal is a legal service provider, the same as a lawyer, and they can give the same privilege to clients as far as privilege goes with respect to legal information or communications given to them by clients. And you also have the ability to give legal advice if you're a licensed paralegal. So I'm going to make a disclaimer right now that I'm not a licensed paralegal. I don't give legal advice, and I don't have the ability to offer legal services unless it's some very particular circumstances. But I'm not going to go into that today. That's not the purpose of this video. The purpose of this workshop is to talk about the similarities and differences of all courts and tribunals. And when we talk about a courtroom and an administrative body like a tribunal, every body will have its own rules. So we're talking about, landlord-tenant issues, or the Canadian Human Rights Tribunal, or the Canadian court system, whether it be a provincial court or a traffic court. They're all going to have their own set of rules and procedures, and it's good to know what they are. But more so, I want to, have this be a similarity in that it's a similarity that every single body that determines issues of law and issues of fact across Canada has its own rules. And, these rules of procedure are mechanisms for determining how matters or files or applications flow through the venue. And when they flow through the venue, sometimes it's not, the same. One procedure can be different from the other, but in general, there are a lot of similarities between how a matter will flow through a jurisdiction's court venue or tribunal or administrative body. And it's always great to know what those inside the administrative field, the administrative law field, we have a reluctance, or even maybe not a reluctance, but we have and some of those values being the fundamental principles of justice. This is all internally developed when we're talking about administrative law. And when we're talking about administrative law, the administrative bodies that dispense issues before it, as far as tribunals and whatnot, and boards and commissions, these administrative bodies, they dispense law not in the same fashion, or they don't hear evidence, I should say, in the same fashion sometimes. And that's because the courts adhere to a strict adherence to rules of evidence. And, I could, name off 8 very important rules of evidence. But essentially what it boils down to is that the rules of evidence govern how and when and what purpose proof of a legal case may be placed before a trier of fact. So what does that mean? It means that the rules of evidence that apply very stringently in courtrooms don't necessarily apply in their fullest in administrative bodies, and that collection, those rules of evidence, are somewhat only dictative to courtrooms. And this is a difference. This is a difference between administrative law bodies and courtrooms, in that the courts adhere to strict adherence to these rules of evidence. And I say rules of evidence, but there are no set rules of evidence. There is no website you can go to that will tell you a definitive list of what the rules of evidence are. But what I can say is that it's a collective of how decisions have come down through the times. So when we're talking about Old English common law, that is really the basis for these rules. But even before that, rules of evidence began their development, in the time of old Greece, where Socrates and I'm not sure of. I'm not going to quote anybody offhand, but what we have is, the development of rules over the years that usually come down in the fashion of decisions. So decisions passed are usually defined by a trier of facts decision or a judge's decision, and that usually sets a precedent. And a precedent can be a very powerful thing, or it can be something that needs to be strengthened. And some of the most important rules of evidence are relevance and privilege, how the court deals with witnesses, opinions, and expert testimony, hearsay, authenticity is another rule of evidence, identification, rules of physical evidence. But I think what kind of makes it to the top of that list is that relevance and hearsay. Those are two very distinct and important rules of evidence that kind of filter their way to the top. If something's not relevant, then it shouldn't most likely be heard before a trier of fact or a trier of law. And if something is hearsay, generally speaking, it's inadmissible in a courtroom. That's not to say that it's not that the same piece of evidence couldn't be admissible in an administrative body, because it could. And an administrative body has more flexibility when it comes to the rules because they are created from statute. Administrative bodies are created from legislation, and the government has created these bodies to deal with specific issues, and therefore they have more flexibility within that realm to make determinations of fact and to weigh on evidence. And I'll get into that a little bit more later. As I've already talked about, the tribunals, agencies, boards, or commissions usually have more flexibility when it comes to rules. And this flexibility could mean that one piece of evidence, as I just kind of stated earlier, one piece of evidence could be allowed in a tribunal, but disallowed and disallowed in a courtroom. And that's because they have different standards. Ultimately, though, the procedure in what we're talking about between boards and tribunals and courtrooms, procedure is where you're going to find one of the biggest distinctions as far as similarities, I should say. It's not really a distinction, but so when those rules are drafted and they are followed within the courtroom or within the administrative bodies, procedure is where you're going to find those rules be as similar as possible. Procedure in a sense of hearing procedure and how the hearing plays out or the trial plays out. So in a sense, the administrative law bodies that we're talking about and courtrooms are dissimilar in a way, but they're also very similar in the regards to with regard to rules of evidence. And rules of evidence can be encompassed in the rules of that particular tribunal or that particular court. And when we talk about practice standards, it is general rule of thumb when it comes down to an issue being determined before the final hearing. And the final hearing essentially is the last step in a file. It's the last step in a matter. And when you're having issues determined typically on a temporary basis or at what are called motions, you are going to find the general rule of thumb is that those are usually dealt with in writing. And motions in general are a way for a party to get temporary relief before an action is completed. And that temporary relief could be getting a temporary injunction, could be determining an issue before the hearing or the trial. It could be summarily dismissing a party's case, or striking part of a party's case. So there are many different things that can occur at a motion as far as the types of relief sought, but most likely what institutes a motion is some paperwork, and usually it's always dealt with in writing, with some opportunity on some occasions to deal with something also in addition to the in writing portion of the motion or the temporary relief, some sort of oral arguments that will accompany the written facts. And the written facts usually will take the form of an affidavit. That's a similarity between the between the courts and administrative bodies. And what you don't see a lot of, I would say very rarely, maybe less than 5% of the time, what you're seeing at motions, a very, very small percentage of time, you're seeing that there is no oral evidence being given. And I want to distinguish this between oral evidence and oral arguments. Oral arguments being the actual facts that one intends to rely on being spoken to because it's already before the court. It's already before the tribunal. And it's already before the court in writing, whether in documentary form or in an affidavit or actual documents. And so arguments are not evidence, and usually, 9 times out of 10, even in an administrative body, you're going to need some sort of substance behind an argument. And that is done by filing paperwork, and usually that will take the form of affidavit, the affidavit in the courtroom and in the administrative body. And what's that mean? It means that you can't argue evidence that isn't before the court. You can't argue evidence that isn't before the trier of fact or trier of law. And that means that you have to file paperwork. You have to file your facts before it comes time to argue the facts. And when you argue the facts, which is a similarity between tribunal administrative bodies and courtrooms, when you argue the facts have to be present. If they're not present, usually you can't argue them. So a similarity is that most motions are done on notice. So with notice of the motion happening and the ability to object to the motion, and that the motions take place in writing. And then, not only do they take place in writing, but they're argued orally. And that's an opportunity to be had, but motions can also be argued in writing as well. But that's probably a little bit more rare, and that's usually reserved for issues that aren't contentious. And that's usually reserved for relief that isn't to dispose of a matter. Although that can be the case in some administrative bodies. So moving on, I breached on a little bit of the rules of evidence and how that is similar or different to courtrooms and administrative bodies, but of the court system and the administrative law system is that in the court system, hearsay isn't typically allowed unless there's an exception. But there are a lot of exceptions. And primarily the general rule of thumb is that a piece of evidence, if it's hearsay, is inadmissible unless there's an exception. And those exceptions can be found in various places. and those exceptions can be found in, say for instance, the Canada Evidence Act, or the provinces have specific acts that deal with evidence. And in Ontario, that's called the Ontario Evidence Act. I'm not going to go through them all, but essentially, there are legislative authorities, or there is legislation that determines what's admissible and what's not admissible. And then there's also the case law that has been set. So precedents from cases before. And in general, hearsay isn't allowed in the court system, and in general, a difference is that hearsay is allowed in, say, for instance, a tribunal like the Canadian Human Rights Tribunal. Now, the Canadian Human Rights Tribunal lists actually in their, and I'm referring to this in particular because it's a good example, under the Canadian Human Rights Tribunal's website, under their tribunal glossary section, they state that while hearsay is accepted, that and hearsay is admissible, that the general weight given to an issue or a piece of evidence, if it's hearsay, is now the factor. So if for instance, in the Canadian Human Rights Tribunal, what they're saying is that if I say, my neighbor told me that that dog is brown, well, that's hearsay, and whether or not it's proper, the Canadian Human Rights Tribunal says that that kind of hearsay is allowed. It wouldn't be allowed in the court system. And it would be allowed in the Canadian Human Rights Tribunal, although what they're saying is that the weight that we give that piece of evidence is going to be a lot lower on the credibility scale as far as information that we receive, rather than a picture of the dog that is brown that you intend to say is a brown dog. And when it boils down to it, those types of exceptions that the court has usually have nothing to do with administrative bodies and when they have evidence come before that is hearsay. So in general rule of thumb is that in tribunals, hearsay is most times permissible, admissible, and sometimes heavily relied on. And that's not the court. That's of case, not the circumstance when we're talking about the court system. And in the court system, there are a few rules of thumb that pop out as being principles about hearsay in general. One leading case on the matter is R versus Starr. And R versus Starr, that's a Supreme Court of Canada case from 2000. The citation fully is R versus Starr in square brackets 2000. Outside of square brackets, it's 2 SCR 144. So R versus Starr is the leading case in Canada that basically reevaluated some principles about the principles of evidence and hearsay. And what also comes from that case is the holding of a principle, the holding of a set of rules called the principled approach. And that's in regard to hearsay evidence. And in the most summary form, the principled approach essentially deals with the exclusion of evidence being equally, that case can essentially allow you to equally use these principles to exclude otherwise admissible hearsay. And it's a very powerful case, and if you get a chance before your matter, you should read this. You should read R versus Starr just because you are representing yourself, and because the chances are you are going to be relying on hearsay at some point. And you're going to try and do it, and the judge is going to stop you. But essentially, what there is to think about is that there are ways to include evidence if it's hearsay in a courtroom, and there are ways to exclude evidence if it's hearsay in a courtroom. And knowing the difference between the two and how to do both is very important. But getting back to my original point is that hearsay is at most times in administrative bodies allowable and permissible. And it's not necessarily the case when it comes to, when it boils down to courtrooms. Procedure is going to vary from tribunals to courts as far as the basic form of hearings. But essentially, what you have is the same type of structure happening in a courtroom, and the same type of structure as far as the hearing goes in a tribunal or administrative body. In an administrative body, you have typically you have an applicant and a respondent. Now, these can have different names in different tribunals. Procedure goes, the most important thing to know is that the basic structure of the hearing or the trial, either in a courtroom or in a administrative law body, those two are different always, or those two are very similar always. So, as I stated, there is an applicant and usually a respondent in an administrative law body. Same is true in a courtroom. And they can have different names. Again, in a courtroom, sometimes you have, in a criminal matter, for instance, you have the Crown, who is essentially the person who's looking for relief. Even though the Crown is a body, it's still considered to be a person. And in a criminal context, you have the Crown, who institutes the proceedings or who prosecutes the proceedings against the other party, which is the defendant. And so you have the Crown or the prosecution, and you have the defendant. And the Crown starts the process, they present their case, and then the defendant gets a chance to present their case. And after that, the Crown gets another chance to reply to anything new that was raised in the defendant's case. And then that is just that's the giving of evidence. That's the giving of evidence portion. At the beginning of a hearing, you'll have typically opening statements. And again, the person who is seeking the relief or looking for the orders to be made originally typically goes first. That party will go first. Now, that could be the Crown, that can be the plaintiff in a civil matter, or that can be an applicant if you're talking about family law. And that's in a courtroom. Obviously, you have the same type of structure happening in administrative law bodies. And when it boils down to it, that same structure happens over and over and over again all the time, no matter administrative law bodies or courtrooms. the person who is seeking the relief originally first gets to speak first, gets to present their case first, and presents their closing arguments first. And then the other side, or the other parties, the defendant, the respondents, or the respondent, or the defendant. Defendant and respondents are the typical names used for responding parties in Canadian law. There may be other names in other jurisdictions, but essentially those are what you're going to find throughout Canada in general terms. So the first party goes, second party or second parties go, because there can be more than one parties, don't forget. And then there is a chance ultimately to respond to the new allegations that have arisen from the responding party by the original applicant or the original plaintiff party, or plaintiffs or applicants. And that's basic structure that will carry on from courtrooms to administrative bodies. And everywhere in between, that's what you're going to find, is that kind of structure. So that's a similarity between the two types of bodies. What you're going to find also is a similarity is that everything is appealable. So you can appeal pretty much everything. There are a few exceptions, and I'll get into that just in a second, but whether it is a panel of judges or a review team that basically they only do reconsiderations or reviews of member findings or member orders in administrative law bodies, there is always the opportunity for review or for appeal. And what is also a similarity is that there usually has to be significant error on the part of the original trier of fact to overturn that original decision. So when you have, a panel of 3 judges looking at a single judge's order in an appeals court, you have to have a distinguished set or even a single error on part of the original trier of fact, or the original judge, or the original member from the tribunal who made the decision. Now, on the very small end of the spectrum, less than 5% of the time, you're going to find that things are not appealable. But in general, across the board, administrative law to courtrooms, you're going to find that pretty much everything is appealable. So that is a similarity. And when we talk about being able to appeal something, that applies to us as society's general fundamental principles of justice. And this is it's a very important thing to keep in mind. It's outlined in the Charter at Section 7. The Canadian Charter refers to the principles of fundamental justice. And the fundamental principles of justice essentially the heart of it is whether or not a hearing is fair or not. it goes to what the consensus is, I guess, of what society believes or should believe is a fair hearing. So what does that mean? It means that if a judge or a member of a tribunal makes an order, it's usually fair and fair process. And going back to the original statement of, it's usually that the principles of fundamental justice are saying that if an error is made, that should be able to be overturned at some point with due process. And due process was, I think it's in the Bill of Rights, the Canadian Bill of Rights. But the fundamental principles of justice is the overriding term that comes across in the Charter. And that is found under Section 7 of the Charter. The reference to the principles of fundamental justice. And, that strikes at the heart of what an appeal is all about. An appeal is if an error has happened but on the part of the judge, that judge should be able to have first of all, the applicant should be able to have a new order or a new hearing, or that judge's order should be set aside and something new take its place. Another similarity when it comes to and I'm talking about appeals just a little bit longer. Another similarity between administrative law bodies and courts are that the higher that an appeal goes, usually the more decision makers get involved to look out and after that original decision maker's judgment. So what's that mean? It means that think of the Canadian court system as a pyramid, and you start at the bottom of the pyramid when you're the applicant or when you're the plaintiff or what have you. And you start at the bottom of the pyramid, and as you go up the chain, if you don't get a successful decision that you're happy with and you think that an error has been made, you go up the ladder or the pyramid of decision makers to review that single decision maker's decision. And the higher that you go, the more judges that are going to become involved, or the more decision makers that are going to be becoming involved. For instance, a panel a panel of individuals may deal with reconsiderations in a tribunal member's decision. And it will typically be a single person that makes a decision at the original stage or the original hearing stage of an administrative law hearing. And then, if that is appealed, a panel of individuals will look at and review the material, review the transcripts, review the recordings of a hearing, and they will determine as a whole whether or not an error has been made and whether or not a new hearing or a substituted decision should be input. At the apex of the pyramid, you have 9 Supreme Court of Canada judges, and 7 sit on a hearing of a matter, so a hearing beyond the initial leave application stage of the Supreme Court of Canada. Let's back up. At the Court of Appeal level, at the Provincial Court of Appeal level in all the provinces, typically what you find is 3 decision makers reviewing one judge. And when you go to the next level up, which is typically the Supreme Court from a Court of Appeal, from a Provincial Court of Appeal, you have at least three decision makers or 3 judges determining on whether or not an appeal even starts in the Supreme Court of Canada. And then you have 7 judges that oversee the appeal as a whole. And so that's really kind of thought of as like the best metaphor is the pyramid. So that is a similarity. Wherever you go, you're most likely going to be dealing with more individuals deciding on a case the higher a case goes as far as an appeal goes. Unlike the court system, so a difference between courts and tribunals is that administrative bodies are set up in their very nature to deal with things in a faster way, to deal with them more efficiently, and to deal with them less expensively. And this is compared to the resolution process traditionally in a court system. And in a court system, you have things that are very complex, usually very costly. And the 2 types of systems, when they're compared, they don't compare. If you're talking about an administrative law body, a tribunal or a board or a commission, that's usually set up to deal with one specific type of issue. For example, labor issues. There are labor boards across Canada, and these labor boards are set up to settle labor disputes. And that's all that they do. And they can do that more efficiently and cheaper by focusing on that one specific realm or one specific topic area. So that's a huge difference between the two types of legal bodies, administrative law bodies, and the court system, is that administrative bodies are set up to be less formal, less expensive, and are set up to be resolving conflicts in a faster manner. A side note to that is that typically the courts, if they see that you had the opportunity to go into a tribunal and hear your matter, and you didn't, that you may be barred from making a claim in a court. And that's a very interesting little side note that you should investigate on your own, and it will depend on the type of hearing or the type of venue that you're looking to go into. So that this is not a general rule. This is tribunal per tribunal, you're going to have different rules. And court by court, you're going to have different exclusionary issues come up as well. So in Ontario, this may be different than British Columbia as far as whether or not you're barred from making a claim in court if it's that if it's that you haven't already made a claim in a tribunal. And it's also good to kind of add to that typically, if you've started a tribunal action and you've started to seek an action in in a tribunal, then a court will usually not allow you to file an action against the same party for the same type of relief in a courtroom if it's being dealt with currently at a board level or at a tribunal level. So that's a good side note, but there's no general rule of thumb when we're talking about this. But generally speaking, you can expect something like that. There's no catch-all for that type of rule to be made, though. Tribunal members. Tribunal members. This is a good difference to note. Tribunal members, or people who sit as members in administrative law bodies, these people are usually, they have expertise or special knowledge in the topic that they are dealing with, or the orders that they're making, or they're asked to consider. They usually have specialty knowledge in that area or that realm. When judges, on the other hand, this is the difference. Judges, on the other hand, are expected to know have general knowledge about a vast array of different areas of law. So, for instance, a tribunal member may have expertise in landlord and tenant issues, and therefore they sit on a landlord and tenant board, and they make decisions on behalf of that board. They are the member or the presiding adjudicator for landlord and tenant issues. And a judge, if you were to talk to that administrative law member who is a landlord and tenant board adjudicator, they might not have any knowledge about, for instance, car accidents or issues that may arise in small claims court. If you're talking about a courtroom, though, that judge that you're going to be before has a vast array of knowledge from a vast array of legal topics. Whether it is a landlord-tenant issue, or whether it's a claim for custody in a family matter or a criminal matter. They're going to have knowledge, a vast array of knowledge in all those different topics. And that's a huge difference and that's a huge difference to understand, to really understand if you're thinking about going into an administrative body over a courtroom. It may suit you better to go into an administrative body if you haven't filed your action yet. It may suit you better to go into an administrative body because they will understand the law or the type of questions of law that will come up in that sector, as opposed to a court that may not have that specific knowledge about landlord and tenant issues. That doesn't mean that you can't resolve landlord and tenant issues in a court, because you can. What I'm saying is that the judge will be not as familiar with specific topics than a tribunal member adjudicator will be. Tribunals are normally established pursuant to federal or provincial law or legislation. And an example of this would be the Employment Standards Act, which is provincial legislation in British Columbia, and that sets out the framework and the governance for the Employment Standards Tribunal in British Columbia. So that particular act basically creates and governs how the Employment Standards Tribunal acts and makes decisions in British Columbia. So there are, so that is, that's a similarity between the court system and a tribunal, is that they are, typically set up, and their history is set up within the realm of legislation, although their powers come from different places. Tribunals draw their powers from legislation and legislation alone, whereas a court can draw its power from inherent power. So power that is inherent to a judge means that that a judge has the ability to make judgments based on what a reasonable person might decide. And that might be also based on common law from years and years ago, from cases passed down throughout the ages. So those principles and that inherent power isn't found within administrative law bodies. Another similarity, and a big similarity, between administrative law bodies and courtrooms are that pleadings are everything. That an applicant or a defendant or a plaintiff or a respondent, you must live and die by your pleadings. First of all, what is a pleading? Pleadings are the written set of allegations or facts, if you will, that have yet to be proven and that set out a party's position. So this is what happened. So these are pleadings. So I say that parties essentially live and die by their pleadings. I mean that if your pleadings don't create a reasonable cause of action, or if your pleadings don't set out a reasonable defense, or if your pleadings don't set out in administrative law bodies, if your pleadings don't set out a reasonable probability of success with a tribunal claim, then most likely you're not going to make it to the final hearing stage. You could have your case dismissed based on your pleadings alone, and whether or not they're strong enough or whether or not they outline a reasonable cause of success. For instance, if somebody's name is misspelled, and this is misspelled all the way up to trial, or all the way up to the hearing stage of the matter, and this person's name hasn't been amended at any point, and this person's name has been misspelled throughout the whole process of the proceeding or the matter, an order will most likely be made in the name of the person that is on the pleadings. There are exceptions. There are exceptions that can happen along the way or at the hearing process. But usually, if an order is made and it's a final order, and somebody's name has been spelled wrong, and it's not the fault of the judge or the decision maker or the adjudicator, then most likely that will stand. And that is usually a fatal error that somebody can make. And that's all contained in the pleadings. The pleadings will contain the names of the parties. It will contain the allegations that are made. It will contain the defense that's being made, if that's the case. So, that is less likely to be fatal in administrative law than it is in a courtroom, but it can be fatal in both administrative law bodies and in courtrooms. So keep that in mind, that your pleadings and the actual facts and it boils down to the relief that you're seeking. If something is improper before the administrative law body or the court, and if something is not formatted properly when it comes down to your pleadings, as far as the relief that you're seeking, that can be an issue that prevents an order from being made. And that is something very good to know. That similarities and differences are, yes, pleadings are everything. No matter if you're in an administrative law body or in a courtroom, your pleadings are everything. A difference is that will become less fatal in an administrative law body because they're more flexible as far as being able to change a name at the last minute, or even if an order has been made. So a courtroom, on the other hand, that's a difference that the courtroom, there won't be success in the style that the person who is seeking that relief is looking for. One of the greatest similarities that you're going to find across the board, courtrooms and in administrative law bodies, is that the process is set up as an adversarial system. And what's that mean? It means that typically, almost always, there is one party versus another party. And they combat and they, try and fight their positions until there's one winner and there's one loser. Sometimes there can be two winners, sometimes there can be two losers. In my mind, though, the only parties or the only persons that are winners when it comes to somebody being in a courtroom or somebody being in an administrative body, the only winners are the lawyers. The lawyers and the people that are making these decisions and the whole process as a whole. Those are the only true winners. The lawyers win because whether or not their client wins or loses, they're still getting paid. And the tribunal system and the court system wins by keeping people inside the system. So, what is the point here? The point here is to stay out of the system. That is the point when I talk about an adversarial system and there being winners and losers. An adversarial system typically, though, means that there's a winner and a loser. And that's a similarity no matter if you're talking about courts or the judicial system in a courtroom. So in summary, there are a lot of similarities and differences no matter what venue that you're in, whether you're in an administrative law body or in a courtroom. There are a lot of differences, there are a lot of similarities, but once you know these basic principles, you should be in a better place. Now here at the workshop in person, I'm going to now do a form session. I'm not going to be broadcasting that for the YouTube channel, but I will offer you an opportunity next time we do a workshop to come out to our workshops and to come out in person, or to request a workshop to be done in your specific area. That's doable as well. But you can find a list of the upcoming workshops in 2016. You can find those on our website, irepmyself.com, and I encourage you to send us a note or send us an email if you'd like to participate, even by way of video conference next time that we do a workshop. And I also want to point your attention to our website. It's going to be updating with some exciting information. Coming up on Sunday, May 22nd in Windsor, Ontario, we're going to be doing a very exciting fundraiser for singles, for people who are dating and who are single. This is a fundraiser dinner and a dance that will also include some activities for speed dating type style of activities. And we have yet to release any details about this, but May 22nd is the date. We just confirmed that today. And if you're in the Windsor, Ontario area, or you're going to be on the Victoria Day weekend, so that's the Sunday which is Sunday, May 22nd. It's going to be a dinner and dance fundraiser. And essentially, the theme behind this is that we are going to be supporting self-represented litigants. And self-represented litigants in general are lonely people. They are lonely people. They have feelings a lot of the time of isolation and alienation in the community, and even with their family and friends. These are the people that we support, self-represented litigants. And this dinner and dance dating event, the singles event that we have yet to name, that we are confirmed on doing now on May 22nd, 2016, this event is going to basically be themed in the style that we are supporting individuals who are dating, who also may be feeling feelings of loneliness and isolation, similar to self-represented litigants. So if you're going to be in the area on that weekend, in the Windsor, Ontario area, on May 22nd, we would encourage you to come down and take a look at our website for updates. Stay tuned on the YouTube channel. We will release some videos and details about the event as we get closer. Thanks for watching, you people on YouTube, and I encourage your thoughts below in the comments section, and send us an email on the website irepmyself.com if you have further questions about anything that I talked about today or about your specific case, because that's what we're here to do. We're here to support people who are representing themselves in legal matters. Although we have and will continue to offer these services to any person who wants them, whether or not they're self-represented or not, that is not an issue for us. We can teach you, as a person who has a lawyer, we can teach you how to communicate better with your lawyer. This is another great feature of what we do. We can teach you how to communicate better with your lawyer so that it costs you less money to have a lawyer. Anyways, hope you enjoyed this video and hope you enjoyed the workshop. Thank you for